Obscene como o channel so ha age politics abri. Podcast of training make we speak headlines na jemre ni bi exumo. Yebo obro chama Wontumi na so ye na okupie mu e court on lawyers. Nsema hodo bi ehwe gu ho a ajemra yi bi exumo pending ni appeal a ode akoto Supreme Court enim say. Omo enhwe na omo emane bill no ombra emeye ni tutuye. Na Bishop say imu wan siblim na enhwe de ko ene de eba. How age politics abri.
This afternoon, convicted Ashanti Regional Chair of the New Patriotic Party, Bernard Nchiboisiako, known popularly as Chairman Wontumi, has filed an application at the High Court seeking bail pending the determination of his appeal against his conviction. The notice of motion filed by his lawyer, Samuel Atachia, of Zo Achia and Co. invokes Section 96(1) of the Criminal and Other Offences Procedure Act 1960, Act 30, and Sections 33 of the Courts Act 1993, asking the court to admit to bail pending the hearing and determination of his appeal. Chairman Wontumi was convicted and sentenced to 20 years in prison after he was found guilty of assigning Akonta Mining's mineral concessions to a third party without prior approval from the minister. We're going to provide you a bit more, right? A bit more in terms of the details as to the grounds for this bail application to the High Court. And I'm going to take you over to the dashboard right now, right? And that's what we're going to walk you through the grounds for the appeal as have been put before the courts. The expectation is that by August 19 of this month, that is where the application will be heard amongst many other things as well. So let's go to the dashboard now, right? And that's where we're going in relation to this subject matter involving Chairman Wontumi, who has been sentenced. He's currently serving that 20-year jail term. There's been appeal of that decision. Now, here are the arguments as have been put forward by his lawyers as to why he must be granted bail pending the hearing of that application for appeal. Now, of the many things, they say that the whole trial was wrong in law and the appeal raises substantial, serious, and arguably questions of law and fact with overwhelming prospect of success. They further argue that the conviction proceeded upon grave errors of law which substantially affected the outcome of the trial. Again, they make further arguments, right? Further arguments that the appeal discloses several exceptional circumstances warranting the exercise of this honorable court's discretion in favor of the applicant. And let's go on to the final argument, if there is. And then they proceed that the appeal raises genuine and substantial constitutional interpretation questions regarding Article 1911 of the Constitution. If you're wondering what that is, as to clearly define punishment for crimes as provided for in law, right? So they argue also that the Leonard trial judge usurped the jurisdiction of the Supreme Court in flagrant violations of Article 132 of the Constitution in terms of who interprets and enforces the 1992 Constitution. That is within the sole preserve, right, of the Supreme Court. The arguments by Samuel Atachia, who is lead counsel for Chairman Wontumi, says that, look, there were constitutional provisions or matters of interpretation in relation to the charges that had been brought against Wontumi with reference to what specific laws he had breached. They were arguing that with that case, the High Court should have paused everything, gone to the Supreme Court for constitutional interpretation. Now, they're arguing that by virtue of the High Court proceeding and given a verdict, they violated the 1992 Constitution, and so it is also a grounds for which they are appealing the decision. Then they argue that sections 13, 8, and 46 of Act 703 exculpates the first and third appellant of all the charges against them and are consistent with their innocence as well. Then they argue that the appeal challenges the learned trial judge's attribution of criminal liability to the applicant, notwithstanding the separate legal personality of the third appellant, right? With this, the arguments they are putting before the Court of Appeal is that when you want to take into consideration who granted that the High Court got everything it was doing right, who was guilty, then the guilty party was Akonta Mining Company. In law, that is a separate legal entity, devoid of who owns it, who is its director, who is its subscriber, and all of that. So the guilty party in all of the things they found against Wontumi should have been Akonta Mining Company and not Bernardin Chibuesiako, because he is a director of Akonta Mining Company and should not have been found liable as to the wrongs done by Akonta Mining Company, because Akonta Mining is a separate human being with respect to law, right? Because it's an entity that has been set up amongst many other things. And if you read that judgment which found him guilty, the judge arrived at the conclusion that, look, Akonta Mining Company is Wontumi, and Wontumi is Akonta Mining Company, simply arguing that there was no distinction between Akonta Mining Company and then Bernardin Chibuesiako, as is expected to be in law because of activities which he undertook, the lack of corporate governance, amongst other things. That was the argument which was put forth by the learned judge in arriving at piercing the veil, right, in legal terms, in going past the separate legal entity of Akonta Mining Company to hold Bernardin Chibuesiako liable for the wrongs of the company. Now, they say that when the applicant is admitted to bail at the trial, he complied fully with all of the conditions of bail, attended every sitting of the court whenever required. So they are making further arguments as to why Wontumi must be granted bail, that when the case was being heard, he was granted bail, and he never for once flouted any of the bail conditions, was always present in court as and when he was needed. And so that is grounds enough, right? Grounds enough for him to be granted bail again, because he is someone who has proven that he respects the decisions of the court, particularly with respect to bail. And if he is granted bail again, he will do likewise. Now, finally, they argue that at no time did the applicant attempt to abscond or evade the jurisdiction of the court. The applicant is not a flight risk as well. So further arguments to buttress the point that, look, Wontumi is no one who is going to run away. He's not going to be in any hurry to leave the jurisdiction because he's adhered to similar bail conditions before, and he will stick and stay in the jurisdiction until his appeal is determined, right? So these are the arguments which have been put forward by Samuel Atachia, who is lead lawyer for Bernardin Chibuesiako, known popularly as Chairman Wontumi. Let's speak to the spokesperson, right, of Chairman Wontumi, Dr. Palgrave Boachi Dankwa. We're going to work the phone lines and have him join us. Right. I get the indication he's joined us as well. Doc, I appreciate you for speaking to us this afternoon. How hopeful are you of seeing through this application?
Thank you very much, Mawina, and thank you for the opportunity as well granted me this afternoon. I must put on record that, yes, yesterday, the bail pending the appeal was filed at the High Court. It was received at about 1:40 p.m., and you could tell that that's very consistent with lawyer Samuel Atachia, because the appeal as well was filed at 1:40 p.m. on the 28th of July before the court rose for the legal break. We are confident that based on the grounds of the appeal, which are 5 grounds in addition to an extra 15 plus particulars of errors that were found in the judgment, the appeal court will sit, and whilst we wait for them to sit either or not during the legal break or after the legal break. We're very confident that this bill that we have applied for, which the hearing would be on the 19th of August, would be very favorable with the High Court to be able to grant us that bill. And so we are very confident about it.
I mean, now that we're speaking to you, many are wondering what is the status of Chairman Wontumi. How is he faring over the last few weeks since the conviction as well?
Well, I'm certain that Chairman Wontumi is faring well. The last time that I saw him was on the last day of court on the 31st of July. He was in court on other pending cases as well that have come to the court against him, which he has pleaded not guilty. And so that was the last time that I met him and spoke with him. I'm very certain that he's doing very well. We haven't received any other news otherwise, but we can still confirm that he's still in his own prison.
That as a party, there are plans to, amongst other things, hold certain activities in relation to his conviction. You've described him consistently as a political prisoner. That's been challenged. But for you as a party, what is the position going forward?
Well, I mean, so you are aware that as a party, we care definitely about the well-being of Chairman Wontumi. The party has clearly stated the position and related this as political imprisonment. We've had the rank and file of the party led by Alhaji Dr. Mahmoud Bawumia, who is the flag bearer of the party, leading the charge to ensure that whatever that we need to do to make sure that the right thing is done in terms of this process is done. Is done very well. The leadership in minority as well in Parliament are also leading it, and then also the headquarters leadership, acting chairman and general secretary Kodia are also doing their bit to be able to help. We have a planned vigil, hopefully on the 14th of August. You have that Chairman Wontumi is still the sitting Ashanti Regional Chairman of the New Patriotic Party, and that's our stronghold. And so the leadership in Ashanti Region are holding a vigil, of course, to remember Chairman Wontumi and to show solidarity to him while he's still in his own prison.
His plans as to becoming national chair of the NPP, what has happened to it? Because you're the official spokesperson of that campaign. Is this one that can be described as lost, or the charge is still on to have him, even while in prison, elected as a national chair of the NPP?
Well, yes, we still, as a campaign, very committed to Chairman Wontumi's ambition to become the national chairman of the party. We haven't received any other indication otherwise as well. His last words to me on the day that he was sentenced on the 20th of July 2026 were that we should work hard to be able to bring Alhaji Dr. Mahmoud Bawumia to power, and that we should also work hard to make him the national chairman of the party, and that he is going to be okay. And so I'm very confident that when the party opens up nominations, we will be able to pick up a form for him. When the party is closing nominations, we'll be able to file for him. And it's the decision of the delegates to make a decision from there whether or not they would want Chairman Wontumi to lead the party. But we are very confident as a campaign and even as a spokesperson that we are going to still stand for the national chairmanship election.
Right then, Doc, I appreciate you for making time to speak to us. That's Dr. Palgrave Boache-Dankwa. He's spokesperson for the Wontumi campaign as they are working to have him be national chair. But Samuel Atachi as well is private legal practitioner and is lead counsel, right? Lead counsel for the chairman of the NPP, Bernard, the Ashanti Regional Chair, I should say, Bernard Ntwi-Boesiako, who's put through this appeal as well. And as and when we're able to get him, we'll get a bit more from him as well. But a bit more in terms of some other stories for you this afternoon right now. And the Regional Coordinating Council of the Greater Accra region, led by the Regional Minister, Linda Oklu, has given property owners along the Laboma Beach area in the Dade Kotoko municipality a 21-day ultimatum to relocate. Now, the minister stated that after the 21-day period, all structures confirmed to be within the buffer zone of the Peshi Lagoon will be demolished. Joseph Armstrong Gold at Logbe is with the inspection team. He's joining us right now with a bit more in terms of an update as to this. Armstrong, talk to us. How many properties have been identified and what more has the minister been saying?
We all witnessed what happened, as a result of the flooding within the Greater Accra region. And so we are here with our best. We want to also assess the level of encroachment because all these places that we are standing are part of the lagoon, which is the Kweshi Lagoon. We have video, unfortunately, I don't know whether it's in the car. You could see from 2022, 2023, 2025, and 2026 the level of encroachment. And so we want to assess the buildings within the buffer zones and then make sure that we give them 21 days notice to evacuate the place, and so that we can create a buffer to store the water. This is where when it rains, it accommodates chunk of the water within the region, and so we cannot sit aloof to make sure that we lose the wetland. And so we are here to reclaim it back. And so that is why we are here. So we've given them 21. You can see that we've marked the buildings within the buffer zones, and so we are hoping that within the 21 days those buildings, the owners of the buildings would either do the needful or RegSec will come in and do the needful for them.
Honourable Minister, we are told the harm has already been caused to where you see these buildings. Some of them are very huge buildings. The question is there no any other way to find a way to protect the remaining lagoon than to pull down all these buildings?
We are, point of correction, we are not pulling down all the buildings. Unfortunately, Hydro is not here, but they are coming to assess the level of encroachment. So they will, guide us as to where we should demolish and where we shouldn't. And so trust me, we are not here to demolish everything here, no. But we are here to create the buffer. So any building that falls within the buffer will be down. And we've done this severally. During our demolition, you've seen that even more huge buildings has been down, and so when you fall within the buffer, why not? Those buildings will come down.
The conversation from many people will be that you are complicit in this, given that you're giving permits to these individuals to construct your buildings.
There is no permit. Trust me. You can find out from the owners. They are all around. So far, we've not, and the assembly are here, and so you can find out. They've not given anybody permit. Even when you go to lands, they've not given anybody permits. And so no one has permit to put out whatever structures here. So we've not given anybody permit to do whatever they've done here.
We asked earlier if you are going to make any arrests because obviously you are going to use state resources to, after everything, would you be picking up people who have no permit but have money to put out such buildings?
Yeah.
We ain't some of the team course or channel so women our Saudi Arabia. That's an so bad in the Adobe Dominion. Unia, the same as